Yeah, well, so we were at the about meeting we were discussing. So the annual general meeting is very important for a company because of the kind of business that is transacted during the meeting, right? So the business transacted at the annual general meeting comprises of ordinary business, which will be dealing with consideration of annual accounts of company, declaration of dividends, appointment of directors, appointment of auditors, and fixing all the remuneration as well. So all those things are comes under the category of ordinary business. Next category we have as special business. So any other matter other than the above shall be considered as a special business. So whatever things we have discussed earlier, other than that, anything will be considered as special business. So the annual general meeting is of great importance, let's say for shareholders, because it is only at this meeting that they can exercise control over the affairs of the company. How? By passing the various resolutions. So that can be done in special business meetings. Other than that, we have legal provisions as well for uh, meetings. The first one is which says, according to Section 96, which provides that the first annual general meeting of a company shall be held within 9 months from the date of closure of its first financial year. Also, the holding of such a uh, meeting is a statutory necessity. Okay. Next one is subsequent. Well, in Section 96, it states that every subsequent annual general meeting must be held within 6 months from the date of closing of the financial year. So there must be one meeting in each calendar year. That is AGM, annual general meeting. Also, the gap between two annual general meetings should not be more than 15 months. That has to be noted. An important point. However, the registrar may extend the time by 3 months. So when the time has been extended by 3 months, the gap between two successive meetings should not exceed how many months? Yes, that is 18 months altogether. Then the Act further provides that no calendar year shall pass without an annual general meeting being held during its course. So that is an important one. Now, the board of directors is the proper authority to convey an annual journal meeting. Also, the company must give a clear 21 days notice to all the members, the legal representative of the deceased members, official receivers of the insolvent members, the auditors, and the directors of the company. So, a meeting can be held with a shorter period of notice if it is agreed so by 95% of the members entitled to vote at the meeting. Also, the notice must specify the place, the date, and the hour of the meeting and must contain a statement of business to be transacted at the meeting. A copy of director's report, audited annual accounts, and auditor's report must accompany the notice. Now, the next thing is in section 96 2 provides that these meetings shall be held during business hours, that is between 9 to 6 p.m., 9 a.m. to 6 p.m. on a day. And that shall not be a national holiday at either the registrar office of the company or at some other place within the city. It is to be noticed that these meetings can be held on a holiday, but not on a national holiday, right? Also, Section 97 states that it is a default. If a default is made in holding a meeting, then the NCLT, that is National Law Company Tribunal, on receiving an application from any member of the members, can direct the calling of annual general meeting. Also, in Section 96, it deals with penalties for not holding annual general meeting. Every officer of the company who is in default shall be punishable with a fine of rupees 1 lakh. In case of default continues, a further fine of rupees 5,000 per day is imposed till such default continues. Okay. Now we have one extra kind of a meeting we should be knowing about that. That is extraordinary general meetings. Well, a general meeting of a company which is held between two consecutive annual general meeting for transacting some special, or you can say urgent business, will be termed as EGM, that is extraordinary general meeting. Well, an extraordinary general meeting is normally conveyed to decide on a matter which cannot be postponed till the holding of meetings. For example, alteration of the objects clause of company or removal of a director, like that. Now, let's see about the authorities who convene EGM, who can do EGM extraordinary. So there is section 100 provides that EGM can be conveyed by the board of directors. Well, the board may, whenever it deem fit, call in an extraordinary general meeting of the company. And EGM can be held at any place within India. It is not necessary to hold these meetings in a place where the company registered office is located, like in the case of AGM, right? So the board must give a clear 21 days notice before holding any extraordinary general meeting. Shortest notice is, however, valid if 95% or more of the members entitled to vote give their consent in writing or by electronic mode. Now, next thing is directors on requisition. Well, in section 102 of the Companies Act, it provides that the board can convene the extraordinary general meeting upon receiving a written request or requisition form. The requisition form is signed by the following requisite number of members. That is, in case of company having a share capital holder of at least 10% of the paid up capital of the company, and in case of a company not having a share capitals, member having at least 10% of the total voting power. Well, the requisition must clearly state the purpose of the meeting, that is, must clearly set out the matters which need consideration. So, on receiving a valid requisition, the board must, within 21 days of receiving the requisition, must move to convene meeting. The EGM requestioned by the members must be held within 3 months of the deposit of the requisition. Now, the next thing is requisitionists themselves. Well, the company is bound to repay all reasonable expenses incurred by the requisitionist in the calling of a meeting. Next one is the tribunal. Well, in section 98, it provides that for any reason it is impracticable for a company to call EGM, then the tribunal may, either on its own motion, that is termed as suo motu, or on application of any director of the company, or on application of any member of the company who is entitled to vote at the meeting, order an EGM of the company to be held. The following leading case, well, the following next thing comes and meeting is the class meetings. Well, the share capital of a company is divided into more than one class of shares. So, the existence of more than one class of share mean that the consent a class or a classes of shareholder is required in order to make a particular decision binding on a company. Class meetings are held to deal with certain matters affecting the interest of a particular class of shares. Such meetings are usually required to be held when it is proposed to alter, vary, or affect the rights of a particular class of shares. Let's say when a company intend to cancel the arrears of dividends on cumulative preference share, it is necessary to call for a meeting, or such shareholders pass a special resolution as required by Section 48 of the Companies Act 2013. Are to be attended by such class of shareholders whose rights are affected. The resolution passed at such meetings are binding only on the members of respective classes of shares. Next thing which we need to discuss is meetings of board of directors. Well, the board of directors is the supreme authority in a company, we all know. So, and they have the powers to take the major decisions in a company. For the effective management of a company, it is necessary that the board meetings are held at regular interval of time. Now we'll look at certain legal provisions of meeting of the board. Well, in section 173 provides the legal provision which are first, board of directors meetings. Well, every company must hold first meeting its board within 13 days of its incorporation. That means within 13 days they need to held their first meeting. Next provision is time gap between two board meetings. Well, every company must hold a minimum of four board of directors meeting in a year, and the gap between two board of directors meeting shall not be more than 120 days. One person company, small company, and dormant company are required to hold at least one board of director meeting in each half year, and the gap between the two board of directors meetings should not be less than 90 days. Okay. Now let's move to next provision, that is notice of the meeting. Well, in section 173 3 provides that a notice of not less than 7 days is required to call a board of directors meeting. A written notice must be sent to all the directors of the company, whether in India or outside India, at their registered addresses, delivered by hand or by post or by electronic means. So every officer of the company who is responsible to give notice as per section 173 of the Act, but fails to do so, shall be liable with a fine of rupees 25,000. Also, section 173(2) of the Act provide the directors to participate in board meetings either in person or through video conferencing or audio visual means. Now, moving on to the next provision, that is quorum of the meeting. Very important, quorum. The quorum of a board of directors meeting is one third of its total strength, or two directors, whichever is higher. So, the participation of directors by video conferencing or by other audiovisual means shall be counted for the purpose of quorum. Also, while determining the total strength, any vacancy in the board of director is excluded, and only the number of directors in office at the moment is counted for the purpose of quorum. So that was provision regarding quorum. Next provision is regarding time and place of meeting. Well, it is to be noted that a board meeting may be held at a time on a day including a public holiday, and at any place other than the registered office of the company. Understood? So that was about time and place. Next thing about is agenda of the meeting. Most important thing. So it is not obligatory under law to send a copy of agenda along with the notice of every board meeting. But good company practice demand that the agenda containing business to be transacted with short notes on each item should be circulated along with the notice at least 1 week before the date of the meeting. Hmm. So the agenda consists of items like appointment of first auditor, appointment of additional directors, company calling for major policy decisions, all those things. Then the agenda shall be conveniently grouped and divided so that minimum time is consumed on less important items. Routine items are generally placed in the beginning, and items which require detailed discussions are taken up thereafter. So that was agenda of the meeting. Next is participation in the board meeting through video conferencing or other audiovisual means. What is the provision? Let's see. So, every director is to be informed of the option available to them to participate through video conferencing mode or other audiovisual means in the notice of the meeting. Every company shall make necessary arrangement to avoid failure of video or audio visual connection so as to ensure that participants attending the meeting through audio visual means are able to hear and see other participants clearly during the course of the meeting. Also, a director may intimate his intention of participation through electronic mode at the beginning of the calendar year. However, such declaration shall not debar him from participating in a meeting in a person. Then the directors also should communicate his intention to the chairperson sufficiently in advance so that the company is able to make suitable arrangements on his behalf. In absence of such intimation, it is assumed that he shall attend the meeting in person. Now, the next provision is placing statutory registers at the meeting. Well, the statutory registers which are required to be placed in the board meeting shall be placed at the scheduled venue of the meeting. Right. Moving on to next provision, that is maintaining confidentiality. Well, from the commencement of the meeting till the conclusion of the meeting, no person other than the person whose presence is required by the board shall be allowed access to the place where meeting is held. Now we'll discuss about the minutes. What are the provision regarding the minutes? Well, the draft minutes of the meeting shall be circulated among the directors within 15 days of the conclusion of the meeting. Also, the meeting shall disclose the particular of the directors who attended the meeting through video conferencing or other audiovisual means. Also, every director who attended the meeting, whether personally or through video conferencing or other audiovisual means, shall give his comment in writing within 7 days after the receipt of the draft minutes, failing which his approval shall be presumed. And finally, after the conclusion of the meeting shall be entered in the minutes book as specified under section 118 of the Companies Act. It has to be signed by the chairperson. Now, the last provision is regarding voting of directors, which is the method of voting to be followed at a board meeting is by show of hands. Voting by proxy is not allowed. A poll can be demanded at a board meeting, even though the usual way of voting is by show of hands. Every director has usually one vote, irrespective of his shareholdings. So one person can vote one time, whether they are holding any n numbers of share, right? So that was about all the provisions regarding the meeting. Now we will move to the next unit, that is unit 11 and 12, that is resolutions and minutes. So give me a minute's time. We will start this unit in a minute. Yeah. So we will be discussing unit 11 and 12 now, which is regarding resolutions and minutes. Well, first of all, let's understand the meaning of resolution. So, the decisions in a company are taken by resolution passed at various meetings. It may be understood that the formal decision of a meeting or any motion before it, a proposal when passed and accepted by members becomes a resolution. Now, there are various kinds of resolution. So, the first kind over here is ordinary resolution, special resolution, and resolution required are special notice. So, first of all, we'll discuss about the ordinary resolution. Okay. Well, according to section 114, an ordinary resolution is the one which is passed at a general meeting by a simple majority of members entitled to vote therein. Simple majority means that the votes cast either by show of hands or electronically or on a poll in favor of a particular proposal, including the casting vote of chairman, exceeds the vote cast against it. So the vote may be cast by the members either in person or by proxy if allowed. Ordinary resolution normally do not require filing with the registrar of companies. The usual notice of 21 days is, however, required for passing an ordinary resolution. Ordinary business transacted at the annual general meeting is as follows. That is, adoption of director report, balance sheet, profit and loss account, and auditor's report. Then election of directors, declaration of dividends, appointment of auditors, appointment of another director, appointment of sole selling agents, issue of shares, and issue of bonus shares, sale of the whole or part of the company undertaking the business. Now, coming to the next kind of resolution, that is special resolution. Well, in section 114, part 2, a resolution shall be special resolution when it satisfies the following conditions. What are these conditions? The intention to propose the resolution as a special resolution has been duly specified in the notice of calling the general meeting. Then, The notice of 21 clear days as required by the Company Act has been duly given. Okay. One minute. Now, the next one is the vote cast in favor of resolution, whether by show of hands or electronically or by poll. So, by members present in person or by proxy or by postal ballots are not less than three times the number of votes, if any, again, cast against the resolution. And an explanatory statement setting out all material facts with respect to special resolution. The nature or interest of a special business to be carried out shall be annexed to the notice of the meeting. So within uh, 1 minute. So within 30 days of passing a special resolution, a copy of the resolution along with the explanatory statement must be filed with the registrar of company. Then also the article of company may provide that certain type of business may be transacted by special resolutions. The Company Act also provide that in certain cases the company must pass a special resolution. Some of the important items which require passing of a special resolutions are to alter the provision of memorandum, altering the object clause in memorandum of association, to alter the articles of the company, to reduce share capital, to issue sweaty equity shares, to change the name of the company, to authorize payment of interest out of capital, to request the central government to appoint inspector for investigation, to authorize payment of remuneration to directors, to appoint an independent director, to issue shares with differential voting rights, and to remove an auditor. So that was about a special resolution. Now, coming to the third kind, that is resolution requiring a special notice, which falls under section 115. Well, a resolution requiring a special notice is not actually an independent class of resolution. Such a resolution may be an ordinary or a special resolution. The Companies Act may prescribe the following circumstances. What are these? For the appointment of an auditor other than the retiring auditor. Then, for express resolution that the retiring auditor shall not be reappointed. Then, for removing a director before the expiry of his term. And for appointing another person as director in place of the director removed. Okay. Now, the special notice shall be given to the company by such number of members holding not less than 1% of total voting power or holding shares on which such aggregate sum not exceeding 5 lakh rupees as may be prescribed or as been paid up. The company in turn shall give its member notice of the resolution in such manner as may be prescribed by the Act that the notice shall be sent by the members of the company not earlier than 3 months, but at least 14 days before the date of the meeting at which resolution is to be moved. The company shall immediately, after the receipt of the notice, give its member notice of resolution at least 7 days before the meeting, exclusive of the day of dispatch of notice and day of the meeting, in the same manner as it gives notice of any general meeting. Also, the notice can also be published in English newspaper, in English language, and in vernacular language. The notice shall also be posted on the website, if any, of the company. So that was about the kinds of resolution, that is the ordinary, the special, and resolution requiring a special notice. Next topic is about minutes and drafting minutes. Give me just a moment, please. I'll just start this topic. Yeah. So we were at minutes and drafting of minutes. Well, there are certain rules of drafting the minutes. Let's check out those rules one by one. Well, the first rule is minutes are like precise, not narrative. So it should not be long. It should be a summarized form. Every company must make entries of the proceeding of its meeting in the book kept for that purpose within 30 days of conclusion of the meeting. The pages of every minute book must be consecutively numbered. Also, each page of every minute book shall be signed by the chairman of the meeting, and the last page of minute book shall be dated and signed. Also, a company may keep its minute of meeting in loose leaf binders, provided the following conditions are satisfied. What conditions? Well, the pages contain minutes are duly typed and numbered serially. Each page is signed by the chairman. The loose leaves are kept in safe custody under the lock and key. The loose leaves are bound at a reasonable period of time of not exceeding 6 months. The minute must not contain any matter which are detrimental in nature, and the minute book shall be kept at registered office of the company for the members to inspect. Okay, so if default is made in complying with these provisions, the company shall be liable to a fine of rupees 25,000, which may extend to 1 lakh rupees. Okay, so that was about the minutes and drafting of the minutes and the penalty. So that was about the resolutions. Now, the next thing we'll discuss is about winding up of a company. So, in today's class, we will be discussing only about the introduction part of winding up of a company and meaning, all those things. I believe this in this class the time won't permit to finish off this unit 13. So I'll just give an introduction about winding up of a company in today's class. In tomorrow's class, I'll try and finish it off the Winding up of a company, unit 13. Then we have consequences of winding up of a company, and the last unit, that is insolvency and bankruptcy code. So let me start unit 13, that is winding up of a company. Give me a minute, please. Okay. Now coming to winding up of a company. Well, corporate collapses, when we talk about it, implies a business failure of the company. So, which may occur due to inadequate capital, fraudulent practices, or inefficient management. Failure to respond to changes, all those things. So, winding up of a company is a process where the life of a company ends and its property is distributed for the benefit of the creditors and its members. Also, an administrator called a liquidator is appointed and he takes control of the company. Mhm. So he collects its assets, pay its debts, and finally distribute any surplus among the members in accordance with their respective rights. Now, coming to meaning and definition, well, winding up is a process by putting an end to the life of a company. It is a proceeding by means of which a company is dissolved, and in the course of such dissolution, its assets are collected, its debts are paid off of the assets of the company. If any surplus is left, it is distributed among the, the members in accordance with their rights. Now, there are certain definitions. Let's check out those. So, in the according to Pennington, winding up or liquidation is the process by which the management of a company's affair is taken out of its director's hand. Its assets are realized by a liquidator, and its debts and liabilities are discharged out of the proceeds of realization, and any surplus of assets remaining in return to its members or shareholders. Also, according to L.B. Gower, the liquidation or winding up of a company, it is the process whereby its life is ended and its property is administered for the benefit of our creditors and members. An administrator called a liquidator is appointed and he takes control of the company. It collects its assets, pay its debts, and finally distributes any surplus among the members in accordance with their right. Also, one more definition is there. It says winding up is a mean by which the dissolution of a company is brought up and its assets realized and applied in payment of the debts, and after satisfaction of the debts, the balance, if any, Remaining is paid back to the members in proportion of the contribution made by them to the capital of the company. Thus, the process of winding up involves realization of assets, payment of liabilities, and a distribution of surplus, if any, among members of the company. Right? So, this was about the meaning and some definitions regarding winding up of a company. Now, there are two terms, which is winding up and dissolution. So, let us understand the meaning of both the thing and the differences between the two. So, the term winding up and liquidation are used interchangeably, but the legal implication of these terms are quite different, and these are fundamental differences between them as regard the procedure is involved. So, the main points of distinctions would be, now let us understand by giving a side heading to point of difference and then discuss winding up and dissolution. So the point of difference over here is, first of all, the nature. So under winding up, it is the first stage of closure of a company, and it involves realizing of assets and paying off liabilities and distributing surplus in, if any. When we talk about dissolution, it is the final stage whereby the existence of the company is withdrawn by the law. Now, the next point of difference is proceedings. Well, any person can proceed against the company which is being wound up. Under dissolution, no proceedings can be enforced against the company which has been dissolved. Next point of difference we could consider as liquidators. Well, under winding up, the liquidator represent the company in the process of winding up of a company. This can be done till the order of dissolution is passed by the court. Under dissolution, liquidators cannot represent the company. Okay, the next thing is procedure. Well, under winding up process is carried on by the liquidator appointed by the company or by the court. Under dissolution, the dissolution orders can be issued only by the court. Next point of difference is debts under winding up. So the creditors can prove their debts, but creditors cannot prove their debts under dissolution. Okay, so these are the differences between winding up and dissolution. On winding up, the company does not cease to exist as such except when it is dissolved. So the legal status of the company continues to exist between the period of winding up and dissolution. Now, we'll discuss about the reasons for winding up. Well, the winding up of a company may arise on account of several reasons. Some of them we'll discuss here, like when the objects for which the company was established has been accomplished, the company is wound up. Then the company is unable to carry on its operation or main objective. Also, when the company dispose of its business or the undertaken to another company or individuals. And finally, the final reason is when the company is unable to pay its creditor in full. So all those reasons will end up in winding up of a company. I'll repeat once again. So when the objects for which the company was established has not been accomplished. So the purpose is not being served. Why the company has been established, the purpose is not being served. So that is the reason the company is wound up, right? Next is when the company is unable to carry on its operation or main object. Why the purpose is not being served, and the operations, whether it is service or the products, whatever it is, they are not able to proceed with their operations, the company will be wound up. Next, when the company dispose of its business or the undertaking to another company or individual, like the company is disposing of its business, one giving off its business to some other company, right, by undertaking, or to any other person. It's giving its business, its company to any other company or any other business. So in that case, the company will be wound up. Also, when the company is unable to pay its creditor in full, so they need to pay to the creditor. So in a case when they are not able to pay to the creditor in full, in that case, the company will be wound up. So these are the reasons for winding up of a company. Now, the next topic here I can see is uh, modes of winding up. Okay, so I believe the time will not be sufficient if I start with modes of um, winding up. So in tomorrow's class, we will be discussing about modes of winding up by tribunal winding, voluntary winding up, procedure for members, voluntary winding up, procedures for creditors, voluntary winding up, then petition for winding up of a company, commencements of winding up, compulsory winding up, differences between compulsory and voluntary. Also, the procedure for winding up under new regulation 2013. So, along with this, last two units are remaining. That is unit 4, the consequences of winding up of a company, and insolvency and bankruptcy code. Okay, so with this, I'll try and I'm going to wind up today's class, and we will be starting our tomorrow class with winding up of a company and with modes of winding up. So, that was all for today. For any queries, any questions, if you are having, you can put down your questions in the chat box, or I have provided my email address to the students. I'll again post my email address in the chat box. If any of you want to ask anything regarding your subject, any doubts regarding examinations or anything, you can you are free to email me, right? Anytime before your examination, do let me know for any queries, any help. I'll be happy to help you out, you people. So I have posted my email ID in the chat box, as you people can see. So for anything, you people can let me know about that. Other than that, I am here for a few minutes more. If anything is there, you can unmute and ask me. So that's all for today. Thank you.